Hold on. Okay, good. That's it. Okay, so the topic for today is going to be the separation of judicial and non-judicial powers. So I'd like to point out that we're beginning promptly at 6 because the license for this session is being will be used as well by Wayne Jones, who has a class at 7. So I made a promise that we're using this license only on the condition that we have to end at exactly 7. So we cannot go beyond 7 because he has a class after this, unless somebody knows that Wayne has decided to somehow move his class or cancel it for today. But in the absence of such information, the assumption is he will be taking over this license at 7, so I don't want to cause any problems. Okay, that's still on. Okay, that's right. Okay, so good. So in terms of key outcomes, you should be able to identify, distinguish, and explain judicial and non-judicial powers, explain the separation of Commonwealth judicial and non-judicial powers, and then cite and discuss key judicial decisions that elaborate on the notions of judicial and non-judicial powers and the separation of Commonwealth judicial and non-judicial powers. Now, before we begin going through the discussion questions, I would just like again to kind of go through the way that by which I handle the tutorial sessions. This was something that we actually discussed last time. I think it was on a Friday when we went through the IRAC format, and I explained that there are at least 2 ways of a spectrum in terms of dealing with a class session such as this. One would be the traditional one, which is quite passive on the part of the students, where the lecturer acts as the expert, as the sage on the stage, and the assumption being that the lecturer is the source of knowledge, and students are just there to listen to what the teacher says, and you're supposed to imbibe whatever the teacher says. And it doesn't require much thinking on the part of students, in other words. That's the traditional way of doing it, and this is probably the way that most of us have grown accustomed to when we were students, and especially during our younger years. There was a lot of direction coming from the teachers. It was essentially teacher-focused. And the approach was obviously didactic in the sense that it was mainly coming from the lecturer going down to the students. But there is another approach to dealing with tutorial sessions, and that is by looking at students or learners as part of a community. And that is when a teacher would actually value and privilege the knowledge that students have. In other words, there is an assumption that when students come to the classroom, they actually bring with them their own knowledge, especially if they've actually read the textbook in advance, gone through cases, and done their own readings, and done their own thinking, and so on. And for that reason, it is the job of the teacher to kind of facilitate the participation of students in that community of learners so that they end up contributing to the pool of knowledge. In other words, knowledge is not just in the mind of the teacher, but there's actually a pool of knowledge out there where the lecturer tries to find a way for everyone to contribute to. And in that case, that is more student-centered. It can get quite uncomfortable to some who are not accustomed to such kind of a teaching style, mainly because it can cause confusion on the part of students when the student ends up confronting a lot of ideas and when the student is forced to think on his own, because in that case, it is possible that the teacher may be less directional, will provide less guidance on what the proper answer is, and enable for the student to arrive at his or her own answer. But again, that can be uncomfortable for some. So what I propose to do, and of course there's the middle ground, where in some cases, the teacher becomes more directive, providing more guidance, and on the other hand, he would also try to get students to contribute to the pool of knowledge. And actually, that is what I have attempted to do. So if you'll notice, when I run our tutorials at the very start, I'd ask students to contribute their knowledge and come up with their own answers. And then slowly we end up narrowing down what the answer should be. And then I say what the answer is. I think that is what we have done so far. And I hope to continue with that because, as I mentioned from the very start, especially in the first 2 lecture podcasts that I gave, I said that I don't want the online tutorial to be another lecture where I'm the only one speaking, like I'm doing now. I would rather give students an opportunity to say something. It's possible that students will end up making mistakes, but that is part of the learning process. Because again, if I replicate what I do in a lecture, then how different is this from another lecture that I would give? Or how different would it be from me just giving a written answer to all the discussion questions? So what I'm hoping to do is really to get students, to get you thinking what the answer is, and pluck certain legal principles that I may not have thought of, because the assumption is that, I may end up formulating certain questions like I did, but actually there were certain nuances that I failed to recognize, or I might have ignored. And therefore, in that case, it will be helpful for you to come on board by contributing. Now, so having said that, do we have any questions or comments or suggestions so far? Questions, comments on?
Yeah, g'day, Manjay.
Yes.
When are you going to put you said a couple of weeks ago you're going to put up week 1 or 2 answers. You're going to put them up 5 weeks later.
Yeah.
Are you going to put up the week 1 and 2 answer things this week?
Yeah, the week 1 answers have actually already been put up. We are now in Moodle. I put them up about 4 or 5 hours ago. The week 2
okay.
answers, I might put them up tonight. Otherwise, I'm going to do that tomorrow morning.
Okay, thank you.
But I'm going to delay giving the answers for week 3 because I gave an extension of the deadline, because there were some students who felt that they needed more time to catch up with the first half deadline for the online participation marks. So I will hold off giving the answers to weeks 3 to week 6 until after next week. Anything else? None? Comments? None? Okay, so we could probably begin. Okay, so again, as I said, unless I look at it and we're kind of running out of time, that's when I'll take a more directional approach. But in the meantime, I would like you to get more involved in trying to answer the discussion question 24. So we will begin by getting somebody to volunteer to read the question, and then I'll ask them to put his or her answer in the chat box. In that way, that ensures that you actively participate in the session. Now, remember, that's actually one pool of knowledge there. Because what I've actually done, if you will notice, is that I actually post in the Moodle site the chat of, the transcript of all chat. So you're actually able to benefit as well from the contributions of all your peers. And oftentimes, I'm actually not in a position to read all of them. So, because, as I conduct the tutorial. So that can be helpful because you get the opportunity to see how other students actually think about a specific question. So we will begin the usual way that I've been conducting the tutorials, and that is to get you to think about the question, give your own answers, and then we will try to, I will then try to be more directive, meaning help you come up and show you what the answer ought to be. Okay, so can I get a volunteer to read discussion question 24?
Yeah, Patrick, I'll do it, Manjay.
Patrick, thank you, Patrick.
Yeah, Jim Freeman was arrested after images of child pornography were found in his computer that was seized by the police. His computer has been seized and searched on the basis of a search warrant issued by a judge of the Federal Court of Australia under the New Security Measures Act, Commonwealth. He challenged the constitutionality of the Act, arguing that in issuing the search warrant without giving him a right to a hearing, the judge breached the rules of natural justice and exercised a non-judicial power that was prescribed in the Boilermakers Rule on the constitutionality of the Act.
Thank you, Patrick. Now, the first thing I need you to do, you've probably come across this question anyway before, I'd like you to put in the chat box whether the Act is constitutional or not. So yes, if it's constitutional, no, if it's not. As simple as that. And then we'll take it from there. So can you do it in the next 30 seconds? Tell me if the Act is constitutional or not. You don't have to give me an explanation. Just say yes or no. Okay, we'll do it in 30 seconds. Depends. Okay, now, the next thing I need you to do is to identify what you think are the legal issues that are here. I've actually identified 3 of them. In other words, it's not a straightforward process of saying, yes, the Act is unconstitutional, no, the Act is not. if you go by the ARAC format, it's crucial that we are able to identify what the legal issue is or the legal issues are. So what I'd then like you to do for the next 2 minutes is to state in the chat box what you think are the legal issues. Thank you, Peter. So I've seen something from Peter here. Very good. Okay, hopefully I don't lose that. So that's the problem. It's beginning to go up now. So please write in the chat box what you lost what Peter said. Keeps on moving. So write in the chat box what you think are the legal issues of this particular case. Okay. How about the others? Just trying to get some of your answers here. It's so difficult to pick up some answers here because the text keeps on moving. So I'm just going to try to capture some that I've seen. And again, this is an exercise in trying to come up with a better answer in your legal memorandum, and it will be helpful as you move on through your law degree. Because if you don't know how to identify the legal issue, you're likely to come up with the wrong answer. Okay. Okay, are we done? Or are we still getting more answers from students? Oh. Okay, hopefully we're done, because as soon as somebody types in something, I lose what I'm trying to copy from the chat box. So I hope you don't have to contribute right now. Just stop now. Don't put anything in the chat box. Okay, so here we go. So those are some of the legal issues that have been identified by students. So some are good, the others are not. Now, this one, for example, I think you see me highlighting things, right? Can you see that? I asked you to, again, this is not in the form of a critique in a negative way. Again, this is just purely academic. So, when I think that, something is done in an incorrect manner, I'm going to point it out without really, attempting to or seeking to embarrass anyone. So what I asked you to do was to actually identify the legal issues. So if you just say appointment of judge or persona designata, what power exercised. Okay, I would have wanted it to be stated as a legal issue. Okay, so how do we go about doing this? Does anyone want to give a comment?
Can I make a comment, Manjo?
Who was that? Audrey?
It's Audrey.
Yes, you could give a comment on what we've covered so far or what you've seen in the chat box. Go ahead, Audrey.
Well, I think in my response on Moodle, I've stated what the legal issue is, and I'd probably like a confirmation or not from you if it is correct. Otherwise, I don't see how I need to get on the right course otherwise. So for me, the legal issue in this question is whether a federal court judge has the power to issue warrants, because you've got a judge in the federal court, but you don't know if the judge is in his capacity in the federal court or if he's acting separately. So the legal issue is whether the federal court has the power to issue warrants.
Okay, go ahead.
Issuing warrants is a non-judicial power.
Hold on.
So federal courts may only exercise judicial power under Australia's doctrine of separation of powers.
We're still in the process of identifying the legal issues. Don't state the rules.
Okay, well, just for clarity, is that the legal issue?
There was a third one. What, did you identify a third one? No.
Oh yeah, sorry, I just unmuted. So does the federal court judge have a power to issue warrants?
Yeah.
Issuing warrants is a non-judicial power.
Mm-hmm.
And no, I think that was it actually. Sorry,
Okay.
I just went on.
Okay, thank you. Let me just make a comment here. In relation to the first legal issue that you've identified, it seems to be apparent that under the new Security Measures Act, the federal court judge has the power to issue warrants. It's there. But that begs the question of whether or not the exercise of that power would be unconstitutional or not. Right?
Yeah.
Comments from the others? Okay, because we're running out of time, I'm just going to do this quickly. To me, we'll just keep it there. The first question is the judge exercising a judicial power? That's the first question. So when I say is the judge exercising a judicial power, is the judge in issuing a search warrant exercising a judicial power? And what do you think is the answer there?
Well, it's no.
No, because there's no controversy. So in other words, this is on his own initiative. Remember that federal judges only deal when there is a matter, and that a matter arises when there's an actual controversy between parties. That is not the case. So we know that in this case, it does not involve the exercise of a judicial power. But we know that under the Boilermaker's doctrine, judges on federal courts, it is not permissible for federal courts to be vested with non-judicial power. So we have a problem here. So if the judge is not exercising a judicial power, is it permissible for him to exercise a non-judicial power? Correct?
Well, I said no.
So that's the second question. That's the second legal issue. So if the judge is not exercising a judicial power, is it permissible for him to exercise a non-judicial power? The answer is yes, in certain circumstances, according to Grollo versus Palmer. And that is one, when it is with his consent under the persona designata doctrine. And second, when the exercise of non-judicial powers by a judge or a federal judge is not incompatible with his functions. Okay, so I'm just doing it quickly. Yes, in certain cases. So that's C, Grollo versus Palmer. Okay, so far? Now, if the judge is not exercising a judicial power, we've clarified that. Is it permissible for him not to observe the rules of procedural justice? So that will have to be the other question, right? So in other words, is it a requirement that a non-Chapter 3 court or tribunal must exercise or must always observe natural justice? And when you speak of natural justice, there are at least two components to that. One is procedural justice, which is the right to be heard. And the other component is that there must be impartiality and objectivity and a lack of discrimination on the part of the decision maker. So the question is there a requirement? The answer is no. So unless the enactment creating the tribunal or empowering a federal court judge to be a member of a tribunal expressly provides or implicitly provides that the rules of procedural justice or natural justice must be observed, there is no requirement that an administrative tribunal or a non-Chapter 3 court observe the rules of natural justice. Had it been different in the sense that this judge was actually exercising a judicial power, and meaning not under this setting, but it was actually just a judge of a Chapter 3 court performing the regular functions of a judge, in all instances, that judge would have been required to observe the rules of natural justice. Okay, so was that clear enough? Clear enough? Okay, so
can you say that again, Manjo, please?
Okay, so in this instance, we have a situation where you have a judge who is part of a non-Chapter 3 court or part of a tribunal which belongs to the executive. So obviously the judge is exercising non-judicial functions. There is no requirement that administrative tribunals or non-Chapter 3 courts observe the rules of natural justice. There is no constitutional requirement, there is no legal requirement, except if the legislation which created the tribunal specifically or implicitly provides that the rules of natural justice must be observed. So in other words, it is not an inherent quality of an executive tribunal or an administrative tribunal or a non-Chapter 3 court to observe the rules of natural justice. It is not an inherent quality of a non-Chapter 3 court. However, I mean, on the other hand, if it were a Chapter 3 court, there is a natural requirement that a judge must observe the rules of natural justice. That is an inherent requirement of a Chapter 3 court, but not for a non-Chapter 3 court. Clear so far? So as pointed out by M. Green, Michelle, I think, so no need to have a hearing. He may have other means of investigating. So hearings can be foregone. There's no need to have hearings and so on in a non-Chapter 3 court. So we're good. We'll move on. Patrick, you want to read, if you could, discussion 25 for us, please?
Yes.
Thank you.
Alston Magpie was arrested after images showing bestiality were found in his computer that was seized by the police. His computer had been seized and searched on the basis of a search warrant issued by a judge of the State Supreme Court of New South Wales under the New Security Measures Act, New South Wales. He has challenged the constitutionality of the Act, arguing that in issuing the search warrant without giving him a right to a hearing, the judge breached the rules of natural justice and exercised a non-judicial power that was prescribed in the Boilermakers rule on the constitutionality of the Act.
Okay. So again, what I'd like you to do quickly in the next 30 seconds is to say yes if the Act is constitutional and no if it is not, in the chat box, please. Okay. Now, with a question mark for Peter. Okay, now, the next thing I'd like you to do is to identify the legal issues, hopefully in the manner that I did in the previous question, because there are some similarities there. So in the next 1 minute or so, can I ask you to identify the legal issues that relate to discussion 25? Okay, so in the next 1 minute. There are actually three, I think. There are three legal issues involved. Can you identify all three? And put your answers in the chat box. So I'm trying to copy what's in there as quickly as I could because they keep on moving up. Anything else? 23. Oops, no, wrong. That wasn't the intention. Okay, so are we done? So I think you're done. If you could stop putting things in the chat box now so I could copy and paste some of the answers there. Now hold on, before I proceed, I'd like to go back to something here in discussion 24 because there was, I think, a problem that I saw there. Hold on, before I forget. Okay. Okay, here we go. I just want you to take note of this. Are there special requirements for an act that allows for seizure of property? Now, we haven't been discussing this, okay, this specific theme. So this shouldn't, assuming that it were in fact a legal issue, this is not a legal issue for the purpose of this discussion question. I am just reiterating that because for the purpose of doing your legal memorandum, it's possible, as I mentioned before, it's very possible for there to be various legal issues. Some of them can be procedural, some of them can involve civil procedure, some of them can involve questions of criminal law, some of them can probably involve questions of civil law. Focus on questions pertaining to constitutional law, that's one. But secondly, do not attempt to try to bring in, Section 51 discussions, meaning does the legislature have the power to legislate in this regard or in this head of power? Do not do that because that is not included in our discussions. Neither should you be talking about human rights or fundamental rights because that is not part of the legal memorandum assessment. That could be covered in the final online assessment, but not for the purpose of the legal memorandum assessment. Have to learn to lip read. What's that? Okay. Oh, I think I should speak slowly. Yeah, maybe that.
I think the previous comment, someone said that their audio had failed. And
okay. Okay. Yep. Thank you, Jamie. So, let's see. Hold on. Was that it? Did I miss something? I thought. Okay. So, comments from the class. So these are some. Okay, we've got something from Louise here. Comments from the class. What do you think of what is in there so far? Comments? Can I get some comments?
Manuel, Peter Ritchie here.
Peter, yes.
From what I could see of it, it's a very similar scenario to the previous question, except where instead of talking about the federal courts, we're talking about state-level courts.
Yes.
And so we'd be looking at whether at a state level the executive can bestow upon state courts non-judicial powers. Would that be right?
Say it again.
We'd be looking at whether the state executive can bestow upon state courts non-executive powers, non-judicial powers, sorry.
You meant state parliament, not the executive. Whether state parliament can bestow non-judicial powers on state courts. Would that be it?
Yeah, effectively, yeah.
Yep. Would everyone agree with that? Would that be the first legal question? Do we agree with that? Yes or no? Can I just see it from the, would that be the first fundamental legal issue that we have to meet or to hurdle? Okay, that's good. I agree with you that more or less that is the way it should be, whether state parliament can bestow non-judicial powers on state courts. And what's the answer here? So we're now moving beyond the identification of the legal issue. We're now going into the application, the statement of the legal rules or principles. Do we follow the same legal principles that we cited in answering discussion question 24? Or do we deal with a different set of legal principles or rules in answer to that specific legal issue? What would be the answer to that legal issue? Whether a state parliament can bestow non-judicial powers on state courts? Yes or no? Can I ask you again to say yes or no and why? Okay, yes, but this time, yes or no, give me the reason. I'd like to see the reason. It's no longer just a yes or no. This time, I'd like you to state in the chat box your reason why your answer is yes or no. Okay. Yep, good. Yep. Keep it coming. Keep it coming. Go on. Not just a yes or no. I want the reason. Very good. Very good. Very good. Okay. Very good. Very good. Very good. Very good. So, very good. Okay. So, can we stop putting things in the chat box now? Because otherwise, things keep on moving up. I won't be able to read them. I saw a lot of very good answers here, which means that you understand the difference between the operation of the doctrine of separation of powers, the difference between its application at the state level and the federal level, which is brilliant. And so I'm very happy for that. As I see the answers here, some are saying that, where's that? So there is no separation of powers at the level of states, unlike the level of the Commonwealth, where you have a partial separation of powers. There is no separation of powers at the level of states, mainly because prior to or upon the Federation of the Commonwealth, the states which used to be colonies were deemed to have the same powers as Imperial England. And in that case, it meant that each state parliament was in a position to not only be a parliament itself, but and be part of and have the power of and be fused with the executive, because the prime minister, the cabinet, or the premier also form part of the state government. But more importantly, the judiciary is actually part of the legislature. So let me repeat: in the colonies, the courts were actually integral parts of legislatures, and that is that is because that is the way it is in the United Kingdom. If you look at the United Kingdom, they have made changes since then. The House of Lords is actually the upper house of the Parliament of the United Kingdom, and the House of Lords is actually the judicial body of the UK. So if you notice there, and it is actually some of the senior members of the upper house who actually also form part of the House of Lords. So it is a special section. So the House of Lords is a special section of the House of Lords. Okay? So that is the same. Now, more importantly, as pointed out by others here, states have plenary power. Or in other words, they have there is a supremacy of state parliaments, so that state courts do not have a power actually to declare as unconstitutional a state legislation. Let me repeat, as a basic principle, because of at the level of states. At the level of states, because of the principle of state parliamentary supremacy, state courts do not have any power to declare state legislation as being invalid. They can be declared unconstitutional, however, if legislation would contravene the Constitution. So that is would contravene the Commonwealth Constitution. That would be the limitation there. So at the level of states, there is no separation of powers. For that reason, it is perfectly permissible for state parliaments to bestow non-judicial powers on state courts. So as you can see, there is a different rule or rules or legal principles that would apply in answer to question 25. When we look at discussion 24, our reasoning was based on the Boilermaker's case. Here, it's a different set of rules altogether. Okay? Now, so what is the corollary question to that? So we say that the answer is yes. What is the corollary legal issue there? Let me just point out something here. There is a statement here that State Supreme Court is a Chapter 3 court, therefore they can issue the warrant. That's strange. I would have thought that statement would have said that because it is a Chapter 3 court, then it cannot issue a warrant. Because typically, remember, the issuance of a warrant happens in the absence of an actual controversy. It is on the court's own initiative. So if we say that it is a Chapter 3 court, then the logical statement would have been that it cannot issue a warrant.
Manjo, I think it's a question, not a statement. It says, can they issue a warrant?
Okay, that's a question. Now, let me just make a clarification there. There are two aspects to this, okay? So on the one hand, a state Supreme Court is in fact part of the federal judicature, and that's acknowledged in the Australian Constitution. Okay, somebody's making the comment that somebody who's talking should mute the mic. Okay, so there are two aspects to this. A state Supreme Court, on the one hand, is a Chapter 3 court, and that is clearly recognized in Chapter 3 of the Constitution. But on the other hand, a state Supreme Court is also part of the court system of states. And for that reason, it is not a Chapter 3 court. So it has two aspects. It has two dimensions. It is both a state Supreme Court, and it is also a federal court. Now, state Supreme Courts are actually creations of states. They are created on the basis of acts of state parliaments. Okay? And for that reason, it is within the power of states actually to change its legislation regarding state Supreme Courts. Except that, under the autochthonous doctrine, which the High Court has formulated, it is necessary that there must always be a system of appeal within states, and that you cannot just remove a state Supreme Court from the judicature of states. Okay, so while there is a lot of influence or a lot of power that states may do in restructuring or changing the composition or even the powers of a state Supreme Court, and enable judges of state Supreme Courts, for example, to perform non-judicial functions, there are limits in the sense that under the autochthonous doctrine, because a state Supreme Court is still part of the federal judicature and is a Chapter 3 court, it is necessary that there will always be that superior court in states. Okay, so I just wanted to make that clarification. So, can we move on? Because I'm looking at there are two other things. So, so the other issue for me would have been, is the state Supreme Court judge exercising a judicial power? The answer is no. Would there have been a prohibition against a state Supreme Court judge? The third question would have been, the third legal issue would have been, would there have been a legal prohibition against a state Supreme Court judge in exercising non-judicial powers? And the answer is no, because there is no separation of powers in states. Okay, so I guess we could move on because we're running out of time, and I'm conscious that at 7, Wayne Jones takes over this license. Okay, can I get somebody again to read discussion question 26?
Yep, I can do that.
That's it. Thank you, Pat.
Alex Cornwell challenged a ruling of the Australian Board of Accountants, ABA, created under the Australian Boards of Accountants Act Commonwealth, which revoked his registration and licence as a Chartered Accountant of Australia. The Act authorised the members of the ABA to evaluate and review, on the ABA's own initiative, the competence and ability of Chartered Accountants registered and licensed under the Act to carry out or perform adequately and properly their functions under the Act. Cornwell argued that the ABA, in exercising federal judicial powers, violated Chapter 3 of the Australian Constitution. Rule on the legal challenge.
Okay, so can I get your answers quickly? Yes or no? Yes if it is valid, no if it is not. As simple as that for now in the chat box. So yes if it is valid, no if it is not valid. Okay. Okay, good. I'm beginning to see some no's there. Okay, from those who said no, can I just hear from you? Would somebody care to take the floor? For the few who said no, and there are not that many of you, would you care to explain why you think this is invalid? Again, purely clinical.
Was the ABA exercising any judicial power?
Exercising a federal judicial power.
Yes.
Okay. And your answer to that is yes?
No, my answer is no.
So in other words, you think that it is valid?
Yes.
Okay. Thank you. So now what I need you to do quickly is, I'm sorry about, trying to do this quickly, but I don't want to get into trouble with Wayne. I made a promise. We're going to end this at 7. So can you do it quickly? Can you identify and put in the chat box what you think are the legal issues in this discussion question? So can you do that now in 1 minute? What you think are the legal issues? Okay, there you go. Okay. Good. Oops, there. Who said that? Somebody said it. I lost it, but okay. Good. Very good. So I'm beginning to see that some of you are clearly able to articulate the legal issue. That's brilliant. Because if you identify the wrong issue, it's useless to be articulating legal principles. Your answer would still be wrong. Okay, we have to begin by first identifying what the correct legal issue is. So I'm seeing some of you are able to clearly identify what the legal issue is, and that's really gratifying. Very good. So some are saying, who are the authorized members? Okay, so can we stop putting anything now in the chat box for me to just be able to copy some of the things there? Okay, so I think this should do for now. This should do for now. So there is a basic question here. If you notice, the ABA has the power to revoke the registration and license of the chartered accountants of some members of the Chartered Accountants of Australia. Okay, the question is, does that involve the exercise of judicial power? So that's one. So does that involve the exercise of judicial power? The other corollary question is, as somebody said, and I don't know who said it, is that is ABA a Chapter 3 court? So it would appear that these are two of the key legal issues. Would you agree that it is these two that would be the key legal issues? Would we be in agreement? Would you be happy with it? I mean, there's a way of probably crafting it better, but in essence, that is, would you agree that that is the legal issue? Very good. Well done. So whoever said that, that's really good. I'm actually seeing a lot of you doing that. So we begin either way. Do we begin by determining whether or not it's a Chapter 3 court, or we could begin by asking, is it exercising a judicial power? Where do we begin? So in the first place, is the ABA a Chapter 3 court or not? Yes or no? Can I see yes or no? Is it a Chapter 3 court? Okay, very good. So the answer is no. Why isn't it a Chapter 3 court? I'd like to see some reasons now. Can you explain your reason why you think this is not a Chapter 3 court? Quickly provide your reasons. Why is the ABA? Because it's established by legislation? That can't be a good answer, because it is within the power of Parliament to create federal courts. So under Section 77 of the Australian Constitution, Parliament has the power to create federal courts. So in other words, there's nothing wrong with Parliament creating federal courts. There. So the answer of Patrick is, it is not manned by members of the judiciary. Right. So if it is a Chapter 3 court, its members must belong to the judiciary, meaning, in other words, they must at least be lawyers. They must be judges. Correct? So this can't be a Chapter 3 court for the simple reason that its members are not judges. They are not lawyers. They don't have a background of lawyers. So, in other words, how do we know whether a court or tribunal is actually a Chapter 3 court? If you look at the lecture notes, or if you look at the lecture podcast, which I already uploaded today, one way of knowing whether or not a court is a Chapter 3 court or is actually a tribunal is actually by looking at its composition. The mere fact that it comprises of members who are non-judges or who don't have legal backgrounds will already tell you that it is not a court like this in this case. So in this case, the answer is no. Now the question is, if ABA is not a Chapter 3 court, is it exercising a judicial power? Because under the Boilermaker's doctrine, the High Court will not tolerate a non-Chapter 3 court from exercising a judicial power. Is it exercising a judicial power? How about the fact of revoking the registration and license? Doesn't that sound to you like the exercise of a judicial power? Okay, let me repeat. The power exercised by the board involving the revocation of the registration and license of Alex Cornwall, wouldn't that constitute the exercise of a judicial power? The answer is no. As pointed out by Shane here, revoking licenses is one of the most common forms of executive power. That's right. I also saw somebody here from Vivian, I think, saying that it involves future rights. There is no controversy. Very good. So that was easy. The perfect case that this should be similar to is the case of Albaran versus members of the Board of Liquidators. Okay, clear? We'll move on. Questions so far? None? Okay, finally.
Hang on, can I just ask?
Yes.
Can I just ask a question?
Yes, go ahead.
Would you be able to write down that case you just said, so I could have a look at it? I didn't catch the name.
Yep. It's actually in the lecture notes.
Oh, okay. Sorry, I haven't had a chance yet. I've been at work today. Thank you.
Okay. Okay, thank you. Yep, there. Very good, very good, very good. Oh, so that's the better one there. It's Albaran, BA, versus companies auditors. Okay, thank you, and liquidators. Okay, thank you. So that's from Andrea. So can we move on to discussion question 27? Patrick, can you read it for us, please?
Yes. ABCD Enterprises went to the High Court to challenge the constitutionality of the Workplace Accident and Safety Board Act Commonwealth on the ground that it vested judicial powers on the board in violation of Chapter 3 of the Australian Constitution. The Workplace Accident and Safety Board had fined ABCD Enterprises a sum of $25,000 after an investigation and a finding that the company failed to properly observe work and safety rules under the Act. Under the Act, an employer aggrieved by a decision of the board may appeal to a court. Rule on the legal challenge.
Okay, so in the chat box, can you say whether the Act is valid or not? So if the Act is valid, say yes. If the Act is invalid, say no in the chat box. Undecided. Okay. Okay, thank you. Now the next question I have here is, can we identify what you think are the key legal issues here? What are the legal issues? Again, in the chat box. So can we start typing in the chat box what we think might be the legal issues involved in discussion question 27? Okay. Okay, we seem to be missing a key issue here. Oops. Oops, no, done there. Okay. Good. So, okay. So we have some of the answers here. Okay, good. So from Molly. Thank you. So the legal issues are whether or not the board was a Chapter 3 court, and 2, is it exercising judicial power or not? Are you happy with that? I mean, are you happy with these answers from Molly? Yes or no? In the chat box. Okay. Yep, I agree with that. Thank you, Molly. So that to me would be the legal issues. So let's try answering the legal issues now. Okay, the first question is it a Chapter 3 court or not? Now remember, the fact alone that it is called a board does not necessarily signify or lead to the conclusion that it is not a Chapter 3 court. Let me repeat. The mere fact alone that a board, a government body may be named a board or a tribunal doesn't mean that it is not a Chapter 3 court. It could still be a Chapter 3 court. Because remember that under the innominate doctrine, there are instances when a certain power may actually be considered to be should be properly vested in the judiciary, or sometimes properly vested in administrative tribunals. So it is up to Parliament sometimes to, okay, thank you, Jamie. Sometimes it is up to Parliament to determine to whom to confer certain powers. So for example, the power to make decisions on certain grants or entitlements, if it may be possible that it can be a subject that will fall within the jurisdiction of a Chapter 3 court, or it can fall to or fall on a non-Chapter 3 court. So under the notion of an innominate power, it's up to Parliament to determine to whom to confer a certain power. Now, so the basic question is this board a Chapter 3 court or not? What's the answer there? Is that a Chapter 3 court? No, is the answer for most. Why not? Can I get the answers now? Why isn't it a Chapter 3 court? What's our basis? Okay, some are saying that because there is no actual controversy, it can't be a Chapter 3 court. Okay, go on. Enacted by an act of Parliament, Patrick. That wouldn't be a good explanation, a good answer, as I said, because Parliament can actually create both a federal court as well as an executive tribunal or an administrative tribunal. So the mere fact alone that it is the Commonwealth Parliament that is creating an agency or a tribunal or a court does not lend to any conclusion as to whether or not that court or tribunal is a Chapter 3 court or not. Because in all cases, it is likely to be the Parliament that will be doing it. So it is not a Chapter 3 court because there is no conflict, there is no actual controversy, it's conducting an investigation. And because it is conducting an investigation, it actually means that it is doing it on its own initiative. And that is not, that does not symbolize the existence of a Chapter 3 court. A Chapter 3 court operates only in the presence of an actual suit or controversy or an action. It does not look for troubles on its own. So when it does, when it seeks to make an investigation on its own, chances are that is not a Chapter 3 court, because it is exercising a non-judicial function, or as Vivian would say, it would be exercising an executive function. Okay, what else? Why would you say that this is not a court? Okay, we'll go to the issue of fine in a short while. Why else would you say that this is not a Chapter 3 court? What else can you see from the facts there? Okay, oh, there's another class in statutory interpretation. So remember, sometimes the way to determine whether a tribunal is a Chapter 3 court or not is by looking at its features or its qualities. So a giveaway would be the fact that its members are non-lawyers. Or you can look at it from the viewpoint of the kind of powers it might have, or the way that it proceeds with certain issues, whether or not it conducts an investigation. So by looking at those features, it can give you an idea whether or not it is a Chapter 3 court or not. Issues also of remuneration, issues of independence, issues of appointment, issues of security of tenure. Okay, so the other one is, according to Anthony, the fact that it is appealable to a court is a giveaway that this cannot be a court. Okay, what else? The fact that properly, how about properly there? The notion of properly. The idea of properly, again, that would indicate that this is not a legal standard. What is proper? That is not actually a legal terminology. That is not a legal term. So the notion of what is proper will probably require the use of discretion. It will probably require looking into certain government policies. And in that case, that is not within the purview of judges or Chapter 3 courts, because Chapter 3 courts make decisions solely on the basis of what the law is. They try to disregard policy and government agendas, or they don't use discretion. So properly is not a legal terminology. Anything else? How about the fact that it imposes a fine? Isn't the imposition of, okay, Peter, isn't the imposition of a fine a hallmark of a Chapter 3 court? Okay, a lot of people are leaving now. Not necessarily, okay? It is in fact a hallmark of an executive function. So it's quite usual for executive agencies to impose fines as part of its regulatory functions. Yep, so Queensland government agent. But again, the example of Queensland government agencies may not be applicable because we're talking here of a federal level. At the level of states, it doesn't really matter whether an agency is exercising judicial or non-judicial functions. It's less crucial. Okay, so I guess that's it. Any questions? Comments? Before we end tonight's, are we missing something else? Now, it's a good thing that no one raised the question of whether or not it was within the power of the Commonwealth Parliament to create this law. That is irrelevant for purposes of discussion 27. We will look at the specific legislative powers of the Commonwealth Parliament in the next 2 or 3 weeks. So what is the answer? The answer is the law is valid because one, the board is not a Chapter 3 court and it is not exercising judicial powers. Okay, so what the legal issues are, is this board a Chapter 3 court? The answer is no. Is the board exercising judicial powers? And the answer is also no. Okay, anything else before we end tonight's session? Comments, questions?
Yeah, I just got a question, Manjo.
Sure, Anthony, go ahead.
Have you got PowerPoints for each week?
For the Zoom tutorials or for the lecture podcasts?
For the Zoom and the lectures as well.
I'll put them up in Moodle. I did that the week 4 Zoom session. I included, I think, the PowerPoint slides. I'll put the PowerPoint slides in Moodle as well tonight. Okay,
thank you.
That's it for us. Thank you very much for joining, and I'll see you next week again. Okay, good night. Bye-bye.